Then after that, you can be able to present to the floor of Parliament. That was my humble request. Thank you.
Yes, I will request to read you also reach out, you meet the Minister for Finance. Because the money being asked for looks a lot of money compared to what the ministry has already given. Okay? So, and you need to go into details, Chair. I can see 4 billion for reagents. Now, reagents, before you get a machine, how are you going to use the laboratory reagents? Honorable Rope? That was,
Thank you, Honorable Speaker. Honorable, I want to begin with some slight house cleaning. It's actually not very slight if you critically look at it. You see, our rules, Rule 204, provides that our reports should be signed by at least a third of the committee members. This particular committee is listed to have 25 people, and the people who signed are less than a third. It's important that, and this is caution to the chairman, it's important that we cross every T and dot every I, because that speaks to quorum. Right, Honorable, you know that some decisions of this House have been challenged successfully so in court because they've been taken without quorum. So we want to avoid situations where somebody can challenge such a report, because it is challengeable if somebody chooses to.
Honorable Rope, I've cross-checked, okay, and I will tell the clerk to upload the report which has enough signatures. I think when we are putting them on pressure, they signed early and it was uploaded. So they will need to upload one which has enough signatures, which I understand the clerk received.
So now it's only the speaker who has the correct document. That's what's the problem. Anyhow, the going forward, we need to improve how we operate.
The document is correct, okay? So the content is correct. The signatures are not affecting the content.
I don't want to get into a debate with the presiding officer, but I think it's important that we caution our colleagues, because the document we have is a different matter. Anyhow, let me move away from that. The point has been made. Right Honorable, I was looking at, colleagues have spoken literally about everything. I'll just focus on one item, functionality of lower level health centers. I think this is important for all of us. Yeah, because you had colleagues complaining about health centers in their constituencies, including ministers who are saying their hospitals are sick and all of that. Can we begin to focus money on this? Because it's important for all of us. As a member, you might get a challenge in your constituency. Sometimes you only think about these things when you're the one in that situation. And the nearest for you to be taken to is that health center. If there is no medical persons, if there is no medical equipment, you'll have a challenge. So let's do this for all of us. And there's where we can find money. I know the Minister of Finance is going to tell us that there is no money. There's where we can find money. Right, Honorable, I made a case here when we went with colleagues to see what was happening at Lubowa Specialized Hospital construction site, which should have been completed a long while ago. As of today, we have injected over 700 billion shillings into that project. Of course, after we made a lot of noise about it, I'm told there is a shell of a structure that has been put up. On an opportune occasion, we shall demand accountability for the 700 billion shillings, because that shell that has been put up, I don't think it accounts for 700 billion shillings for a specialized hospital that should have been completed a long while ago. And there are comparisons that we can make. Honorable Speaker, there is a hospital in Turkey, in the region called Kateriet. I might be mixing up the name. It cost $200 million, a specialized hospital. A 1,500 bed hospital. One of the ministers recently got treatment at that hospital. I'll not mention which one, but got good quality medication, which obviously they couldn't get here. $200 million. For Lubowa Hospital, we have spent close to that. And this is a 264-bed hospital. That's what it's poised to become. So there's just so many things that are confusing. And that's why I was saying, instead of continuously injecting money into what seems like a white elephant, why don't we appropriate this money to health centers that are in place already? Their problem is there is no drugs, there is no equipment. Why do we not do that? Because this entity we are injecting money in, it's a white elephant, and I call it so deliberately, because we don't know what's coming thereof. Each time you keep coming here for more money, we don't know what's happening. Even when we want to go and inspect, we are not late to go and inspect. Why are we continuously injecting money into something we cannot touch? It's like groping in the dark. But we have our health centers, our health facilities, all of us in this house. Why do we not appropriate this money to those health facilities? So I'm saying, while we shall be told there is no money to deal with these issues, that money can be found. That's the only thing I wanted to talk about right now.
Thank you, Rob. Honourable Minister, and you don't need it to answer each and everything. Focus on issues related to the budget.
Thank you so much, Right Honourable Speaker and colleagues. Right Honourable Speaker, I want to thank the chairperson of the Health Committee and the entire members for a good report that spells out how far the health sector has walked the journey and where we are walking to. Honourable colleagues, through you, Right Honourable Speaker, I do appreciate and feel your concerns. I'm also a member of Parliament representing a constituency where all these facilities and issues you are raising, if I was to be the other side, maybe I would raise more. But I do agree with the right Rob and Enos, Asim Honorable Enos, and every member of you. Every time there is issues come in here, it's a concern of each and every one of us. And we all feel that we must have a healthy community if we have to have a healthy economic nation. Right Honourable Speaker, again, I want to appreciate you for having guided or given us information that the health sector has unfunded activities near at 1.7 trillion. And we are at the time of budget processing. Rob and other colleagues have said this is the time where we can all come together as the members of this august house, appropriate money to the health sector. All issues that have been raised, Right Honourable Speaker, if you had the chance also to raise issues in your constituency concerning the health sector, I think someone, somewhere, we should move. There was a question Right Honourable Speaker and other colleagues raised. If as government we can prioritize some sectors and through here and say parish development, metro, the roads, the what, at this time of budgeting, why don't we now make the health sector the issue? Generally, international, the health sector should have 15% of the budget. But the health sector is the least budgeted. And it is the drive factor, the drive force of everything. So I want to say that I do appreciate the committee report, where the ministry, and it is my prayer that together that we look into that and funding, sufficient funding is given. Right Honourable Speaker, even at times when the funding is saying you have passed it as you have said, the PET scan which you have said is in the budget process for the financial year. And we are all saying that it is an urgent matter. Now the question to my colleague, it is in the budget. But what the Speaker and the members were saying, Can't we? Yes, in cabinet we have raised it. And we are saying anyone here has anyway, what I'm saying is, Right Honorable Speaker, the members are concerned that while it is in the financial year, the question is, and this is what Rob said, is there no way we can find this money and ensure we have this paid as soon as possible? As soon as possible. The ministry we have been asking. As soon as possible. The financial year is coming in July, operationalized maybe August. We are moving. The members are saying, Minister of Health, when you look at what we have at the Cancer Institute, the Right Honorable Speaker can bear witness. He has been there. I've been there. Many colleagues have been there. Everyone has been there. Our concern is, through you, Right Honorable Speaker, to find a way and means to sit with my colleague. In the cabinet we have said it, that this is an urgent matter. It's an urgent matter, and very urgent, and a matter of high concern. I leave that one. Right Honorable Speaker, all the issues that have been raised, they concern the insufficient funding of the sector. Give us the money, and then come and ask, you have this money, you have not implemented. Right Honorable Speaker, the issues of the policy was to bring services closer to the people, that we must not have people walking long distances going to the hospitals, congesting the hospitals, when some diseases can be worked at the lower level. And that's why we moved in, and we said the policy we should have at each sub-county, health center 3. Give us the money, then ask us, we gave you money for this health center 3. Why isn't it constructed? Why isn't it constructed? The issue is of wage. The wage that we have, as a ministry, we have the structure that has been approved, but we don't have the wage. So we have a structure. Give us the wage, and we recruit, and we put them there. So I see you are pointing your fingers at me, who has been here for some time, and I'm still with you. So this belongs to all of us. When the health sector, if you want to have a strong economy, we must think about the health sector. If you want the equipment to be maintained, it's not a matter of opening. There must be money, sufficient money allocated for maintenance of the equipment. Some of the equipments are new. They cannot be operated because of the wage. So I think this is the right time. All of us members, whatever questions you have asked, thank you so much.
Thank you.
Can we put our heads together and we give money to the sector? I thank you.
Thank you. Honorable colleagues, I now put the question that the report of the Committee on Health on the Ministerial Policy Statement and Budget Estimates for financial year 2025-2026 be adopted. Those in favor sign to the contrary nay. The ayes have it. The recommendations of the committee are referred to the Committee on Budget for harmonization, reconciliation, and consolidation in line with Rule 149 of our Rules of Procedure. Congratulations, Chair, and thank you very much, Honorable Minister. Honorable Musa Ichweru, the road.
So, well, I congratulate my colleague But I just wanted to give information to my brother-in-law, Honorable Atkins. The road that he talked about, I had to step out, Right Honorable, to check what is going on. The truth is that, yes, there were some delays, but I'm happy to report that the contractor who has been given that road has been directed this morning to start what we call forward maintenance as he prepares to do the actual work on rehabilitation of the entire road. Thank you.
Thank you. I could see you had compromised Honorable Atkins by bringing out issues of cross-pollination on the floor. Yes. Thank you. Next item.
Item number 4 on the order paper, Bills Committee stage, the Sugar Amendment Bill 2023.
Yes. Honourable members, on 7th of February 2024, we started the committee stage for the Sugar Amendment Bill 2023. We stood over the bill because we had some of the clauses which had an impact on subsequent clauses. We stopped on clause 3, whereby we needed the Attorney General to guide us on a few things which we've done, and also to have more talks and negotiations and reconciliation between the mirrors and the outgrowers. So we now resume from where we stopped. Thank you. Colleagues, I think it will be very important for us to first give a minute to Honorable Bahati to update us on the negotiations and engagements that we had between the farmers and the mirrors. Honorable Bahati.
Thank you, Mr. Chairman and colleagues. Yes, we adjourned and agreed to do more consultations. I want to report to the House, Mr. Speaker, that we have held consultations with the farmers, with the millers, with members of parliament from the sugarcane growing areas, namely Busoga, Bunyoro, some parts of northern Uganda, and also to confirm that after the consultations, we have agreed on a number of things, including the composition of the council, the formula, and we are now ready to continue the process of legislation. But also to update the House that we want to thank you, Mr. Speaker, for the work and the time you have put in this bill. You have chaired yourself almost like 4 meetings, and you have worked long and hard to ensure that these negotiations come to a close. So we are now ready, and we have been informed by you, Mr. Speaker, that His Excellency the President has been consulted by you. He's in harmony with the proposed amendments that we are going to go through. So we are now ready. We are at peace and harmony to pass the Sugar Amendment Bill.
Thank you. Thank you, Honorable, and I want to thank the colleagues who participated, because every day that we delay to sort out especially issues of the formula, the outgrower is losing out. Clerk.
Clause 3.
Chair.
Thank you so much, Right Honourable Speaker. Proposed amendments to the Sugar Amendment Bill 2023, Clause 3. Substitution of Section 3 of Principal Act. Clause 3 is amended by A, numbering the proposed Section 3 as Subclause 1, and B, inserting immediately after the Subclause 1 the following. The Council shall be a body corporate with perpetual succession and a common seal, with power to sue and be sued in its corporate name. Justification: establish the council as a legal entity in order to reduce the liability of individual members.
Thank you. Government?
Mr. Chairman, we agree with the amendment.
Thank you. Honorable colleagues, I put the question that clause 3 be amended as proposed. Those in favor say aye and the contrary nay. The ayes have it.
Clause 3 as amended.
I put the question that clause 3 as amended stand as part of the bill. Those in favor say aye and the contrary nay. The ayes have it.
Clause 4.
Honorable Katari Roy.
Thank you, Chair. Suggesting an amendment to clause 4. Clause 4 of the bill is amended. Substitution of clause 4 of the Principal Act. Clause 4 of the bill is amended in the proposed section 4 as follows. A, in the proposed subsection 1C, by substituting for the word 4, the word 3. B, in the proposed subsections 1, D, E, and F, by deleting the words who shall have no right to vote. C, in the proposed subsection 3, by substituting for the words in consultation with stakeholders milling sugarcane or growing sugarcane in Uganda, the words from among the persons nominated by the sugarcane outgrowers and sugarcane millers. D, Mr. Chair, by inserting immediately after the proposed subsection 3 the following. The tenure of the office of the chairperson of the council is 2 years and shall be held in rotation among the representatives of the sugarcane outgrowers and representatives of sugarcane millers. Justification, Mr. Chair. 1. The amendment proposed subsection 1C is to give outgrowers more representation in the council since there are more outgrowers than sugarcane millers. B. The amendment proposed in subsection 1D, E, and F is to allow representatives of ministries responsible for finance, agriculture, and industry to participate fully in the affairs of the council. And D. And lastly, Mr. Chair, the requirement to have the chairperson appointed from representatives of millers and outgrowers on rotation basis is to ensure that no group monopolizes the chair of the council. I beg to submit.
Thank you. Government?
Chair, we have studied the amendment of the honorable member, and we think it can bring harmony within the council. So I agree with the amendment.
Thank you. Honorable Nanda, further amendment?
Yeah, Mr. Chairman, if you look at the council, there is only a chairperson, but there's no provision if the chairperson is absent. I wanted to bring a clause, maybe clause, if we add another clause, I don't know the number, maybe 7 according to this, that in the absence of a chairperson, the members in the meeting shall choose among themselves a chairperson of that meeting. The justification, a person can never always be there as a chairperson. As a human being, can fall sick, and if a chairperson is not there, the people may decide not to call a meeting because it's not available.
Attorney General.
Thank you very much, Right Honourable Chair. Right Honourable Chair, that amendment will not be necessary, because if you look at Schedule 2 of the Principal Act, it provides the chairperson shall preside at every meeting of the board, and the absence, the members shall elect from among their number an acting chairperson. So that provision already exists in Schedule 2 of the Principal Act. Thank you.
I agree.
Thank you. Honorable colleagues, I put the question that clause 4 be amended as proposed. Those in favor say aye and the contrary nay. The ayes have it.
Clause 4 as amended.
I put the question that clause 4 as amended stands part of the bill. Those in favor say aye and to the contrary nay. The ayes have it.
Clause 5.
Clause 5. I received a notification from Honorable Chobe, engineer, that he has an amendment.
Thank you, Mr. Chairman. Clause 5, amendment of Section 5 of Principal Act. Clause 5 of the bill is amended in paragraph A in the proposed subsection 1 by substituting for the word 4 the word 2. Justification: reduce the tenure of office of members of the council to ensure that many people get the chance to be members of the council and are able to bring in new ideas regularly, and all players can participate in the regulation of the sugar industry. I beg to submit.
Thank you. Government?
Chair, since this is a council that has a private sector dominating it, we agree with the reduction of the years from 4 to 2, so that there is flexibility.
Thank you. Honorable colleagues, I put the question that clause 5 stands. I put the question that clause 5 be amended as proposed. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 5 as amended.
Colleagues, I put the question that clause 5 as amended stands as part of the bill. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 6.
Honorable colleagues, I put a question that on clause 6.
Clause 6 are saying they will not be entitled to a salary, but honorary. Who will be the one? Is it going to be allowed to charge tax?
I think clause 6 should come maybe as a consequential amendment, because clause 12. Can you repeat what you're saying for the Attorney General too?
Mr. Chairman, this is about remuneration of the people serving on council. I want to find out from government, if you are saying they will not be paid, where will they be getting the money from when somebody has been invited for a meeting? Is it going to have its own way of collecting money to run it, or what?
Attorney General.
Thank you, Right Honourable Chair. Yes, this the sugar board will generate, as we get along through the council. The sugar council will generate funds from both the millers and the growers, their own funds. So they are not getting salary from government, but the council will determine what they will be paying to their people.
If that's the case, we have here a representative from the Ministry of Finance and Trade. Who will pay these ones? Will they be paid by government, or they will be paid also like council? Because you are paying council members.
Honorable colleagues, that's why I thought we can make this a consequential amendment. We first handle financing issues, okay? Because the council has powers to regulate itself. When you look at this bill, it's in such a way that we would want these people to go and regulate themselves. So they will determine honoraria and all that allowances that are related to sittings, okay? Yeah. Yes, Honorable Adiomu.
Chair, maybe the information I want to give to the colleague is that even the government representatives are taken as members of the council.
Thank you. Yeah. Honorable Eku.
Thank you, Honorable. Take you a little bit back, the composition of the council.
No, Honorable, that's not how. Please, that's not how we work. That's covered. We already beyond that. Okay. Yeah. In legislation, when we are on this stage, you have to be very cautious so that you don't lose track. Okay. Yeah. Honorable colleagues, I put the question that clause 6 stands part of the bill. Those in favor say aye, to the contrary nay. The ayes have it.
Clause 7.
Honorable colleagues, I put the question that clause 7 stands part of the bill. Those in favor say aye, to the contrary nay. The ayes have it.
Clause 8.
Honorable colleagues, I put the question that clause 8 stands part of the bill. Those in favor say aye, to the contrary nay. The ayes have it.
Clause 9.
I put the question that clause 9 stands part of the bill. Those in favor say aye, to the contrary nay. The ayes have it.
Clause 10.
Honorable colleagues, I put a question that clause 10 stands part of the bill. Those in favor say aye, to the contrary nay. The ayes have it.
Clause 11.
Honorable colleagues, I put the question that clause 11 stands part of the bill. Those in favor say aye, to the contrary nay. The ayes have it.
Clause 12.
Clause 12, I have notification from Honorable Kiki Florence.
Thank you, Chair. Substitution of Section 17 of the Principal Act. Clause 12 of the bill is amended by substituting for the proposed Section 17. It is amended by inserting 2 clauses immediately after Clause 12, the following. Amendment of Section 28 of the Principal Act.
Honorable, you see, we go clause by clause. So you've brought 12, okay? So
Yes,
let's first sort out issues of 12. Whereby on funding, whereby I've picked the principle that issues of funding details in terms of managing the funds will be in the regulations. They can't be in the main. That's what you are pushing. Thank you. Government?
Chair, since we are not establishing a new fund, we concur with the proposal by the member.
Honorable Adiomo?
Yeah, Chair, thank you. Chair, my worry is the minister again to determine, but when we have the council. Chair, I would propose that maybe we can leave the council to determine that instead of the minister determining.
Attorney General?
I think the issue here is that we needed the minister to make the regulation. So it is determined by regulation, and it is in consultation with the council. So if you do not have the council, you can't move to make the regulation. So that's where the issue is.
What about, Attorney General, what about instead of saying in consultation, we say on recommendation? Would it be better? So that the council meets, makes recommendation.
Without it, you cannot do the act. So even once you do not have the consultation, you can't do the act. So the minister cannot move without the consultation.
Honorable Taylor?
Right Honorable Speaker, so Right Honorable Chair, when we go with recommendation, the Attorney General will not own those regulations and the contents therein. But in consultation, he also brings in other legal considerations that speak to those regulations. So the appropriate word should be consultation and not recommendation.
So Honorable Adiomo, you okay?
Yeah, Right Honorable Chair, I concede.
Thank you. Honorable colleagues, I now put the question that clause 12 be amended as proposed. Be amended as proposed. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 12 as amended.
Honorable colleagues, I put the question that clause 12 as amended stands part of the bill. Those in favor say aye, and to the contrary nay. The ayes have it.
New clauses.
Was Honorable Taylor? I had, was it Honorable Akiki? Honorable Taylor? I have many notifications.
Prince Akiki had raised a concern on clause 12, and so I was inviting her to raise it at this stage because you had asked her to delay it until we finish the previous clause.
No, and clause 12 is done. So a new clause now.
Yes, that's where she had proposed the new clause after clause 12.
Okay. So Honorable Akiki?
Thank you, Chair. The bill is amended by inserting two clauses immediate after clause 12. The following: amendment of section 28 of the Principal Act. Section 28 of the Principal Act is amended by inserting immediately after subsection 2 the following: 3. The regulations made under this Act shall be laid before Parliament within 4 months from the commencement of this Act. Insertion of section 29 in the Principal Act. The Principal Act is amended by inserting immediately after section 28 the following: the transitional provisions. 1. The minimum percentage of 55% referred to in the formula to determine the minimum price of sugarcane under Schedule 3 to this Act shall take effect 24 months after the commencement of this Act. 2. Notwithstanding subsection 1, from the commencement of this Act, the minimum percentage percentage of sharing proceeds prescribed under Schedule 3 shall be 50%. Justification: to stagger the application of the minimum percentage of 55% for 2 years to enable the industry to adjust operations before the percentage takes effect.
Honourable Minister.
Chair, we agree to the amendment.
Honourable colleagues, I now put the question that a new clause be inserted in the bill as proposed. Those in favour say, and to the contrary, nay. The ayes have it.
New clauses.
Chair, the committee.
All right, Honourable Chair. Insertion of new clauses immediately after clause 12. The bill is amended by inserting immediately after clause 12 the following. Amendment of Section 19 of Principal Act. Section 19 of the Principal Act is amended by substituting the word board, wherever it appears, the word minister. Amendment of Section 20 of Principal Act. Section 20 of the Principal Act is amended in subsection 1 by substituting for the word board the word council. Amendment of Section 21 of Principal Act. Section 21 of the Principal Act is amended in inserting 1 and 2 by substituting the word board the word council. By inserting immediately after Section 3 the following. Section 3A, the council shall within the time prescribed by the minister by the regulations consider the application and make recommendations to the minister to grant, to not grant a license, to grant or not to grant a license. 3B, where the council does not recommend...
Chair, I think we go clause by clause.
Clause by clause.
Yeah, you have different clauses, so okay. We need... I think the first one is a consequential clause,
yes, which
whereby we have substituted the board with minister. Okay.
Then minister with council.
That is for 19, Section 19. I hope you have the act.
Section 19, yes.
Is that okay, Attorney General? I need it on record.
Yes, Right Honourable Chair, the consequential amendment of replacing the minister with council is okay in Section 19.
Because I say members, they are saying should be with council, you can just enlighten. Members are saying it should be council, so just enlighten. Highlight Section 19, what it says for now.
Section 19 of the Principal Act, shall say that a person shall not establish or operate a sugar mill, jaggery mill, or plant, process any without the valid license granted for that purpose by the board. So the proposal by the committee is to replace the board with council.
Yeah, but now it's saying minister.
I beg your pardon. I read the Section 19 of the Principal Act is to replace the provision referring to board with minister under the Act, as proposed by the committee, and we agree with that proposal.
And why?
It's a licensing. Licensing is a factor of regulation. So once you have been authorized by the council to do this act and you get a recommendation from them, then the person who issues you with a license to participate in that space is the minister.
Okay. Yes, Honorable Baiga.
Yeah, thank you very much, Right Honorable Chair. Within that amendment, I would want to find out whether that recommendation it has the force that the minister may not refuse to offer the license. Because
But
we
a
need that
minister
guarantee.
A minister should have power to either accept or not accept, to issue a license.
But we need also those reasons why, under circumstances under which the minister may not accept. So this parliament should clear that. Because we
Honorable Wadiomu.
Thank you, Right Honorable Chair. Right Honorable Chair, the reason as to why we are saying that it should be a council, because in the Principal Act is the board. So instead of what we are amending from the board to the council. So I think everything should remain to the council instead of bringing in again the minister, because in the Principal Act is the board, not the minister.
I think here there will be need to read section 19, section 20, and section 21. So section 19 is a prohibitive section. It is prohibiting you from doing something, that you cannot do that without the minister. But the process of the application is in section 20. And the participation of the board is in section 21, what now we'll have as the council. So it's a recommendation of the council for which the minister issues a license.
Okay.
So if you look at section 21, maybe if it so pleases you, Honorable Chair, we could address section 20. We could just stay this over for a minute so that we address section 20 and 21 so we can go through those together and then we can come back to that. Because the recommendation is by the council to the minister. Thank you.
Okay.
Chair, I wanted clarification from either the minister or the Attorney General as to whether the license being talked about here covers the laborers. Why do I say this? The sugarcane industry has relied on cheap labor from West Nile for a very long time. Even from Acholi, there's a man who worked for 47 years. The only thing he went back with is a bicycle. And now, I will, if it covers, move that during the consequential amendment, I need the laborers to be part of the council. Because we don't want exploitation anymore, the minister should clarify whether the license being talked about here covers those who will supply labor or covers the labor to the sugarcane industry.
Attorney General, I want you to liberate West Nile from providing cheap labor.
I can understand that, but I think we may stray into a space that is we may not be able to regulate, because labor is offered freely. A person cannot be required to provide the labor they do not wish to provide. Now, if you say that we should have the laborers in here, then they have become participants in the business, which they are not. So I think what we can do is we have sufficient provisions in the Employment Act which address any challenges that an employee may have in our Employment Act and the necessary labor legislation.
So the Attorney General made a request that if we could handle clause 20 and 21, then it would help us on the other clause, so that we don't amend in anticipation. What if the other ones are not amended? We just have them as consequential clauses. So I would propose that.
Chair, I think my issue is not addressed to my satisfaction. Why? What is happening is you have companies that go and pick people from the villages, and then they come and give them to the sugarcane industry. And oftentimes, nobody is speaking for these people. I think if we want to regulate the industry and get value from it, we must ensure everybody in the value chain gets benefit. And that means we must be able to regulate the activities of people who supply this kind of labor, and there must be guarantee for those. That's why I was saying there is need for these people to be represented if the license they are so covers that kind of activity.
Honorable, issues of employment, please, the Attorney General guided. The Employment Act, let us not mix roads, okay? Let's be very clear. Chair.
Amendment of Section 20 of Principal Act. Section 20 of the Principal Act is amended in Section 1 by substituting for the word board the word council.
Chair, when you propose an amendment, you give a justification.
Honorable Chair, to harmonize the provision of Section 19, 20, and 23 with the principle of the bill relating to the grant of licensing by the Minister on the recommendations of the Council. To penalize a miller who pays below the price set by the formula by having his or her license revoked by the Minister. The requirement is to establish a sugar planting capable of supplying at least 50% of the installed capacity of the miller, is to ensure self-sustainability in the period where there is insufficient supply of cane from outgrowers.
Thank you, Chair.
Submit.
Attorney General.
Thank you, Right Honourable Chair. We have no objection to the proposed amendment in Section 20 to replace board with council.
Thank you. Honourable colleagues, I put a question that Section 20B amended as proposed. Those in favour say aye. It came in as a new clause. Honourable colleagues, I put a question that a new clause be inserted as proposed. Those in favour say aye, and to the contrary nay. The ayes have it.
New clause.
Honourable colleagues, I put a question that the new clause stands part of the bill. Those in favour say aye, and to the contrary nay. The ayes have it. New clause, Chair, 21.
Amendment of Section 21 of the Principal Act. Section 21 of the Principal Act is amended.
Yes. A new clause. You're amending 21, Section 21 of the Principal Act. So we needed to insert.
Okay, insertion of a new clause. In subsection 1 and 2, by substituting for the word board, the word council.
That one we've already passed.
We have
Chair.
passed, yes. There is an insertion by inserting a new subsection immediately after subsection 7 as follows. I beg your pardon, Chair. By inserting immediately after subsection 3 the following. 3A. The Council shall, within the time prescribed by the Minister, by regulations, consider the application and make a recommendation to the Minister to grant, to not to grant a license. 3B. Whether the Council does not recommend a grant of a license to the applicant, the Council shall, in writing, notify the applicant of the decision. 3C. The applicant shall, within 30 days of receipt of the notice of the decision of the Council made under subsection 3A, apply to the Minister for redress. 3D. The Minister shall not make a decision on the application for a license where the Council refuses to recommend a grant of a license to the applicant until after the expiry of the time prescribed in 3C. In subsection 6 and 8, by substituting for the word board, the word Minister.
That is C.
Yes.
Because it is important for numbering, Honourable.
That is C. I've ended there.
Yeah. Chair, I have D in your...
I have read it.
D? Because you've stopped at C. D. Chair, can you
A,
read
B,
D?
C, D. I read D, Honourable Chair.
Can you read D again so that I'm with you?
The Minister shall not make a decision on the application for a license where the Council refuses to recommend a grant of a license to the applicant until after the expiry of the time prescribed in subsection 3C.
Then C.
The applicant shall, within 30 days of receipt of the notice of the decision of the council made under subsection 3A, apply to the minister for redress.
You know, I read through your report and I received everything, so I try to reconcile to ensure that what is in the report is
Okay, Honorable
what,
Chair.
what you're reading here. So just let me consult here the report.
Okay.
Chair, if I may consult with you and AG, just a little. Chair, resume.
In subsection 6 and 8, by substituting for the word board, the word minister. By inserting a new subsection immediately after subsection 7 as follows. 7A. A miller shall, within the time prescribed in subsection.
Chair, I'm sorry for interrupting you, okay?
Yes, Honorable
Yeah,
Chair.
but now, you see, they have to number when they are polishing and coming with the law. You have C in subsection 6 and 8 by substituting for the word board, the word minister. Then D by inserting a new, you get it, eh? So give me the detail of each. Where you have a C, where you have a D, we capture it on the record.
Okay. So 7A.
That's under D.
That's, yes, under D.
So
7A.
start with D.
Okay. A miller shall, within the time prescribed. 7A.
Chair, let me see your.
Thank you so much, Chair. C.
Colleagues, Chair, Chair took over this in between. So the way the report had been captured, and so she's doing a great job.
Thank you so much, Chair. Continuation on C. C, in subsection 6 and 8, by substituting for the word board, the word minister. D, by inserting a new subsection immediately after subsection 7 as follows. Chair, 7A. A miller shall, within the time prescribed in subsection 7, establish a sugarcane plantation capable of supplying the miller at least 50% of the miller's installed crushing capacity. E. By substituting for the section 9 the following. The principle of the bill relates to grant of license by the minister on the recommendations of the council to provide for a procedure for grant of license by the minister to empower a person aggrieved by the decision of the council not to recommend him or her for grant of license to seek redress from the minister. The requirement, I could finish. Honorable Chair. The requirement to establish a sugar plantation capable of supplying at least 50% of the installed capacity of the miller is to ensure self-sustainability of millers in periods where there is insufficient supply of cane from outgrowers in order to ensure security of supply of sugarcane to the suppliers. A big subject.
Thank you. Government.
Thank you very much, Right Honourable Chair. Right Honourable Chair, we do not have a problem with the proposed amendment A to subsections 1 and 2. We have no objection to the amendment B in as far as 3A is concerned, but just to make a clerical error, the committee report reads that the council shall, within the time prescribed by the minister by regulations, consider the application and make a recommendation to the minister to grant, and it has to instead of to grant or not to grant. Right Honourable Chair, we have an objection to...
That's a clerical
correction. It was just to replaced by or, but for 3D, we would seek members to reconsider, the committee chair and members to reconsider, because it reads, the minister shall not make a decision on the application for a license where the council refuses to grant a license to the applicant until after the expiry of the time prescribed in 3C. Right Honourable Chair and colleagues, 3C relates to the time within which a person aggrieved by a decision could apply to the minister. So once a person applies to the minister, the operation of 3C has ceased. So we're proposing that 3D be dropped because the decision of the minister, when made, they are proposing that that can be appealed to the court as you go further down. We have no objection to the rest of the proposed amendments to Section 21.
Thank you. Yes, Honorable Adiomu first. Yeah, the reason first. Yes, Honorable Adiomu.
Thank you, Honorable Chair. Honorable Chair, that's why I had that worry of replacing the body with the minister. You know, there is a situation whereby they wanted to create zoning, in that by giving all the powers to grant or not to grant to the minister, then it will create a situation of zoning, because a minister can either grant in a certain radius that maybe we are not granting this factory to come here or this miller to put here a factory. And by doing that, it will be one way of indirect way of creating zoning. So I think I'll go by the chair's recommendation that the minister should not have a decision against the council. Why? Because already we have the council, and one of the whatever, and the council has the mandate. And if we are saying that the council is having the mandate, but again for their, one of their mandate is just to recommend to the minister, meaning that the council will not have anything to do. Thank you, right, Honorable.
Attorney General.
I think if my colleague is agreeing with the committee, then he's really agreeing with me. because I just agreed with the committee. The only thing that I said was that the minister, D, removed D. So we are on the same page.
Chair, I'm saying that we should not remove D. Because D is saying that the minister should not have a decision, or to reject a decision of the council.
Honorable Attorney General, okay. Just to arrest the fears of the member, I need you to help us. The member is saying that if the council recommends that company A be granted a license in this area, okay, the minister should not have powers to reject the decision of the council. That's what I'm picking. Because the member is fearing this minister, because it's like a self-regulated industry. So he's saying if the council gives, the role of the minister would be to issue the rights.
I think here we need to agree, and I agree with the member that the minister may hold a different view from that held by council. But why? That's what we are saying. That's why we are talking about dual processes. The council makes a recommendation to grant or not to grant. So if the council makes a decision to grant, and the minister says, I don't think it is correct, you don't have a problem with that. But if he says the council refuses, because the argument we are having here is that even the council itself, what you are trying to prescribe against the minister, even the council itself could be a subject of that same issue. So here what we are saying, let me finish. Here what we are saying...
Honorable colleagues, I'm going to give you time, okay? Let's allow one another. When one is on the floor, we give them time. Yes, when one is on the floor, we give them time, they finish, then I allow you.
So,
let's listen. Yeah.
What the committee has done, it has said, council sits through the application. So in the application process, the minister is not participating. The council makes a decision. The only way the minister gets involved is when a person is aggrieved. An applicant, if the council sends a recommendation to the minister to grant or not to grant, and the person who applied does not complain, the minister can't get involved. The minister can only do that which the council has recommended. But this clause is saying where the applicant is aggrieved, he goes to the minister and says to the minister, the council has mistreated me for these reasons or those reasons. And then that is when the minister can get involved in making a determination whether to grant or not to grant. But the committee has gone further to say that even when the minister has made that decision, if a party is aggrieved, maybe now the council is the one that doesn't agree with the decision of the minister, it can then apply to the court to review that decision. So it's important, colleagues, that this applicant has got a remedy provided to them in case a decision is made which they don't agree with. Beg submit.
Thank you, Honorable Joab.
Chair, I want to agree with the Attorney General because the minister is a minister of government. And the spirit behind this amendment is that the minister is deemed to be as neutral as possible. But the council has interest because it is in business. Yes, in fact, in the council, we have the millers, we have the growers, and we have the representatives of the minister. But this council, to me, I feel can be more biased when it comes to recommendation of individuals to enter into this business. So I agree that the minister should really maintain that status.
Thank you. Now, Honorable colleagues, I don't want us to have an exchange on this because Attorney General has put it very clearly that the minister will only be involved if a party that has applied is aggrieved. Okay? And where are the situations of being aggrieved? They've denied me a license. I applied to the council, they denied me a license. Honorable Batua.
Thank you, Right Honorable Speaker. I seek clarification on that very matter. The Principal Act that we are managing, that is the section
we are not managing here. We are
the Principal Act we are amending, that is section 21, has only 3 subsections. However, when you look at the suggestion of the meeting, it is citing subsection 6 and 8. And in those 2 subsections, first I should confess that we are blind as to which 6 is talking about and as to which subsection 8 is talking about. And in being that blind, we now see that the word board in those 2 subsections where we are blind should be replaced or substituted with the word minister. So we wonder the functions that should have been of the board that actually are going to the minister. And if those 2, if subsection 6 and 8 is listened to properly, maybe it will clarify the position the minister is trying to state. So I ask that the committee rereads subsection 6 clearly and subsection 8, and we see its effect.
Don't accept to be blinded. It's very simple. When you're introducing something beyond what is already provided, that's why it becomes a new clause. So when you're having a new clause, you can go beyond, okay, what was provided in the, what is in the Principal Act. For example, if the clauses being amended around section 21AB, okay, and you have new ones, you can add on, you go to C, E, F, G, and all that. That's number 1. Then 20, we agreed that we shall come to it later because it's a consequential amendment. Once we agree that the powers of the license don't stop at the board, but go to the minister, okay? Then we must go back to 20. So it's a consequential clause, but it can only be consequential if we agree with section 21 and 22. Once we finish those ones, then you will have amended the other ones indirectly, so you must go back and you amend it. That's 19, section 19. Yeah. I had, Honorable Kamba, you had an issue on the same. Then Honorable Taylor.
Thank you, Chair. I have a problem with the proposal because Machias Delande Attorney General is saying that it can be dual, but the section says if the applicant is aggrieved. We may need to change to say the aggrieved party. Then it can cover both the applicant and the board in case the board is aggrieved with the decision of the minister.
Attorney General.
I think if 3B and C relate to the applicant. If the applicant is aggrieved, if the applicant goes to the board, makes an application for a license, and the board, for example, says no, the applicant is aggrieved, and the applicant can go to the minister. But if the board is aggrieved, rather if the council is aggrieved, you go to 9, which says the insertion that the committee is proposing, a person aggrieved by the decision of the minister, whether it's the applicant or the council. You go to 9, that's when you apply to the court. So the aggrieved parties can be 2 in respect to a decision of a minister, but the aggrieved party can only be 1 in respect to the decision of the board. Of the council, sorry.
Honorable Taylor.
Honorable Chair, the spirit of creating the council with a composition of farmers and millers is to create a self-regulating entity that shall give very proper guidance to the sector. The reason why we are not comfortable with the view that the decision of council should be vetoed by the minister is because we do not, first of all, want to politicize the sector. We want it to continue self-regulating in a business manner. But number two, it is more convenient for an individual to go to court in case he's aggrieved than getting the consensus of council members whom probably if the matter was put to vote and 4 are saying yes and 3 are saying no, these ones will even oppose the resolution of council to go to court when they are going against the decision of the minister. So we rather say the aggrieved party should go.
Is on of granting a license on recommendation of the committee. Honorable Chibadia.
Thank you, Chair. Chair, you remember very well when we were in the consultative meeting you called. And these are the scenarios we tried to avoid. That's why you called those meetings. And the Honorable Minister, Honorable Bahati was in the meeting. And we agreed clearly that the powers of the minister will be to grant after the council has agreed. We are putting a scenario where we are giving also room for the minister is also having space to say, if the council says no, I can say yes and we can find a way. Or if the council says yes, I can say no. This is what we are discussing here now, Chair. I would request, we agreed in principle that the minister will take the decision of the council. The minister will not sit in office and also do something different from what the council has done. That's why we say that if there is any party that will be aggrieved, that party will go to court. That's what we discussed.
Haj Idi.
Thank you, Right Honorable Chair. Chair, the consultative meetings that you held, we are trying to cure such scenarios. Because if you consider the Principal Act, we are only replacing the board for council. So what the board ought to have done in the Principal Act, that is exactly what we would expect the council to be doing. So if we are giving a minister room also to determine whether to be a board or council, I think when the council recommends, because the council is the regulator, the promoter of the industry. So I would really ask the Attorney General information.
But Honorable colleagues, I'm allowing you time to debate. Now when you interrupt each other with information.
Yeah, thank you, Chair. Chair, the information I wanted to give, that the minister in the council is already represented. The minister is already represented. There are 3 members representing the government.
So let's
meaning that if again somebody who is having a representative, again you are sending the same person to take the decision where his representative is.
Haji, just wait a bit. Haji, honorable colleagues, we had a long process that members are referring to. A long process. So if members are saying that if you are aggrieved by the decision of the council, you go to court. Are you getting me? Yes. You can go to court. This didn't come from government. This came from the committee. It's not a provision of government. So chair of the committee. No, it was not your provision. It was a chair. It was a provision of the committee.
Thank you so much, Chair. Chair, we concede. On 3C, the applicant shall within 30 days of receipt of the notice of the decision of the council under subsection 3A apply to, the honorable colleagues are saying apply to a court of competent jurisdiction to review the decision of the council. That should be the council, not the minister in this case.
Yeah.
So we agree to that.
Honorable colleagues, I put a question that the new clause as proposed be inserted. Those in favor say aye, and the contrary nay. The ayes have it. We can go back to clause 20. Colleagues, we've already moved on from that. Can we go 20? Consequential, 19. It's 19, consequential amendment. Can we go to 19? Honorable colleagues, when I put a question, just allow me to move, okay?
Amendment of Section 19 of Principal Act. Section 19 of the Principal Act is amended by substituting for the word board, where it appears, the word minister.
That's a consequential amendment. Yes. Honorable colleagues, a consequential amendment, you don't discuss it because you've already passed 20 and 21. Yeah. A consequential amendment? No, please. That cannot be a consequential amendment. That becomes
Chair, if you just allowed me.
Honorable colleagues, you see, go to our rules. When you hear why I was referring to members, the moment you want to propose anything to do with the new clause, you must write to the speaker, to the clerk, you must give notice early. All these new clauses, they gave notices. So we cannot have new clauses on the floor. So let me first put a question on the one they've brought, okay? Honorable colleagues, I put a question that clause 19 be amended as proposed. Those in favor say aye, and the contrary nay. The ayes have it.
New clause.
Honorable colleagues, Honorable
Chair, having established that the role of the minister in checking the excesses of the council has been removed, it is important that we have, alongside the millers, outgrowers, and government, we have the workers represented in the council. The council is a body which takes care of the interest of the various stakeholders, and we cannot be seen to be protecting the interests of a few when the workers in all these growing areas are being exploited. So I therefore move that the workers must be represented in that council so that they are able to take care of the interests of the workers. And they can do that through their representatives or the unions. And that is not been provided for. You have provided for millers, they are 3. You have provided for outgrowers, they are 4. You have provided for government, they are 3. So why should you leave the workers out? And yet they are being exploited every other day. As much as you want to protect your outgrowers, you must protect our workers. We are tired of people being exploited. The government should have been the one to stand for these people, and the minister's powers have been removed. So the only protection we can accord these people is by giving them a space where they will be able to express their concerns so that these concerns are discussed and a solution is found for them. I beg to move.
Honorable colleagues, I think you're also going to move that we have cleaners. We also have those. But let me go to our rules. Please, let me go to our rules, okay? I want discipline in the house. Let's go to our rules. Colleagues, we conduct business according to rules. You have been with this bill for long. You have been with the report for long. Rule 134, sub-rule 4 of our rules of procedure. The committee of the whole house shall consider proposed amendments by the committee to which the bill was referred, and may consider proposed amendments on notice. That's why members gave me notice. We don't read from here. You've been with the bill, you've been with the report, you've not given notice. Okay? I received. Honorable, you don't access the microphone like that, please. These are not issues of emotions, issues of the law. Okay? And it's not consequential in any way. Okay? Because it is a matter of the law. We have a law which was already giving. If you look at the Principal Act, the Principal Act already gave these people this representation. The Principal Act, it gave farmers 4, it gave mirrors 3. Yeah, so there is nothing like a consequential amendment here. Please, Honorable Jan, please.
Thank you, Right Honorable Chair. Chair, I agree that members intending to introduce amendments should first seek your indulgence in writing. Perhaps that would be the general rule, but I would...
No, not a general rule, it's what your rules say.
Yes, I would suggest that there be exceptions in high-stakes circumstances like we are in at the moment.
So what is high stake about this?
The members' submissions concerning amendments that really affect their...
Honorable, you see, let me tell you, colleagues, you will get a situation where you read from here. Why we give you these reports in advance is to go and prepare. Members prepared. I have Honorable Chobe, I have Honorable Akiki, I have Honorable Taylor, I have Honorable Haji Idi, they all brought in amendments, okay? Listen to me. You have your Principal Act. So, Honorables, Jan and members, okay? Now, composition, okay? Composition of this board is in 4, section 4 of the board, section 4 of the act. That's number 1. Number 2, in the bill, again, they also proposed the composition of the board, or of the council. So what I'm meaning is simple. All along, it's an issue that has not just risen. If it was an issue, okay, that had not been provided for example, you insert a new clause that talks about composition of the council, and it has just come. I allow amendments that have just come. But if it is something which is historical, then I don't handle it as an emergency. Please, that's my ruling and that's my guiding. Honourable Minister.
Chair, I want to comfort the honourable member that 1, we have enough laws regarding the labour issues in the country. The second point, the member was worried that the powers of the minister have been removed. That is not true. That is not true. The members, the powers of the minister have been restricted only in matters of licensing. But the minister has the powers to do regulations. The minister has the powers to appoint the council itself. So the member should not get worried about the powers of the minister, though I welcome his sympathy that the minister should have more powers, but the House has said, be restricted, and as far as the licensing is concerned. But other issues, really of regulation, if we find that there is a problem in the sugar industry regarding the workers, we come in and intervene. There's no restriction about this. But we have enough laws. We have a whole ministry of employment, labor. There is a state minister for labor, there is a minister for labor. So there should not be a problem. And when we mix so many issues of workers, regulation of licensing of the sugar industry, we can actually get a problem in the sugar industry by mixing so many issues. So I want to appeal to the member that be comforted. The powers of the minister are there. We regulate, we appoint the council, and we have government is in position to handle matters of the workers in the sugar industry like we handle workers of other sectors. in the country.
Thank you. I have discussed this with the honorable colleagues. You remember we just passed the Employment Act. Now, it was handling issues of casual laborers, people being denied their jobs and all that. Most of these were covered. But number two, I've explained to Honorable Lee how marked on other roads. When you check the road, you check the road to Tanzania and other roads, there's nowhere on the board that these people are involved. And then number three, even contributing financing, because these people are in business with each other. We are regulating a business relationship, how they are interacting with each other. So, but now, you can see what Honorable Guzuri is saying, Honorable Minister. I think the Minister for Labor, we should have time to come and discuss issues of laborers that are exploited, generally, in very many sectors. It can be in cotton, it can be in coffee, it can be anywhere. Yeah? Okay? On which code? Because we finished already, this closes. No, Honorable, please. We don't repeat the same. We have...
New clause.
Chair, 22.
Amendment of Section 22 of Principal Act. Section 22 of the Principal Act is amended. A. In subsection 1, by substituting for the word approval by the board, the words the recommendation of the council and approval of the minister. B. By substituting for subsection 3 the following. 3. A person who wishes to modify a meal shall seek the recommendation of the council and the approval of the minister. C. By inserting immediately after subsection 3 the following. 4. The provision of section 21 shall, within the necessary modifications, apply to an application of modification of a meal. Justification. To harmonize the provision of section 22 with the principle of the bill relating to the grant of licenses by the minister on the recommendation of the council. To request a miller who seeks to modify a meal to seek the approval of the minister.
To require.
To require. Yeah. I beg your pardon, Chair. Yeah. To require a miller who seeks to modify a meal to seek the approval of the minister. To provide for a procedure for applying to the minister for modification of a meal. Beg to submit.
Honourable Minister.
Right Honourable Chair, in light of the discussion we've just had, with the council looking to regulate itself and remove the minister, this was the proposal from the committee. However, in the Principal Act, the modification had always been left with the board, which is now replaced by the council. We propose that we leave the provision of section 22 as it is in the current legislation. Beg submit.
Sorry. Yes. Honorable Batua.
Thank you, Right Honorable Speaker. We've debated severally on the interference of the minister in the works of the council, Honorable Chair and colleagues, recognizing that actually even the chair of the council is appointed by the minister and that there are PSs there, some of these approvals should be left to the council to sort out. They have technical people. Really, we should see minimum political interference with the council. So I pray and suggest in agreeing to insert that new statement, they do the recommendation. Should do actually the approval. We should not have recommendation, but we should have approval, an approval process handled by the council. So the word recommendation should not suffice. Let the process be managed by the council and concluded by the council, and the minister only gets to be informed.
I think that's what the Attorney General was also saying. Okay. Because really, why should the minister be involved in the modification of a bill?
So our proposal is that the provision of Section 22 of the Principal Act remain as it stands in the bill, in the Act now.
Yeah, and that satisfies what Honorable Dr. Batua says. We just do the consequential amendment of the board, just changing the board to council. To council. Yeah. Thank you. Chair, it's you.
Chair, we concede.
But Chair, there was also under that you had changing from board to council. Okay, so we can do it later. We can come back to that.
Right, Honorable Chair, we were proposing that the proposal by the committee be adopted only to the extent that where board appears in Section 22 is replaced by council, but the rest of the provision remain as it stands in the Act.
Chair, do you agree with the proposal?
Yes, Chair, we agree.
Thank you. Honorable colleagues, that's very straightforward, Honorable Chubadi. I don't know what you want us to state about that.
You are going to move the motion. But Chair, we wanted the Attorney General to clarify on something which we are passing. In our areas, Chair.
What is something? Here we don't deal with something.
It's the one it's what I'm mentioning.
Yeah,
it's what I'm mentioning, Chair.
Yeah.
Chair, we have used a blanket statement to say meals. Now meals, we have not defined the capacity. In the area where we grow sugarcane, we have cottage industries and jaggeries. And the word modification may affect a person who has a jaggery, just improving it on something, or these cottage industries that manufacture some few things. Is this person also supposed to seek permission from the council? Because these are small industries.
When you're licensing for the sector. You don't license for small, for big. It's a sector.
Chair, this is where the worry is. Now it's affected. It's going to affect these people who have these small cottage industries.
Yes, but they should. Because now, Honorable Chibadia, your problem you have been having is simple. That you have a sector which is not regulated. Now, you want to have a sector that regulates some and doesn't regulate others. Let everyone come clean. Let all of them reach in. Then, under the council and in regulation, they will go into the inner details of the small ones, the process of the small ones. They can say, for example, the small one can be handled by the subcommittee, Jaggery. Then the big ones can be handled by the full council. Those are details which you go in. But you can't go, you say, we are rejecting people who produce waraji. You say distilleries, for them they should be, but we have these ones who use drums and all that, they shouldn't be. No, sector. What will be the purpose of the law? Honorable Minister.
Chair, the English say you can't eat a cake and have it. you are not going to organize the sector and then also remain with some parts which are disorganized. The reason why you want to regulate this sector is really to bring everybody on board and have the benefits of the proper regulated and organized. So even the small ones, when we are doing regulations, we shall take care of that. We shall take care of that. So there shouldn't be any problem, Honorable Morris.
Honorable colleagues, I want to put a question that Section 22 of the Principal Act be amended as proposed. Those in favor say aye. To the contrary, the ayes have it.
Section 22 as amended.
Honorable colleagues, I put a question that Section 22 as amended stands as part of the bill. Those in favor say aye. To the contrary, nay. The ayes have it.
Clause 13.
Honorable Chair. Honorable Oi Kata gave me notice on clause 13. Huh? It was a kick. You know, I got many. Anyone with an amendment of clause 13.
That is
Honorable, you need a microphone to go on record.
Thank you, Chair. Clause 13, substitution of Schedule 3 to the Principal Act. Clause 13 is amended by substituting for Schedule 3 the following. Formula to determine minimum price of sugar cane. PC, which equals PS times R times D, where PC is average price of sugar cane per ton. PS is average price of raw sugar per ton. R is redundant to be fixed at 8.5%. However, millers and outgrowers may negotiate for redundant above 8.5%, subject to prevailing circumstances. D is the minimum percentage of sharing proceeds shall be 55%. Justification: to provide a fairer formula for determining sugarcane prices.
Honorable Minister.
Chair, I agree with the amendment, and this is one of the things that we have been looking for, to harmonize the formula. I want to confirm to the members, because there are some fears from the farmers, that how about those farmers that have already negotiated and signed agreements of the arrangement of above 8.5%. We want to confirm that those amendments, those agreements will continue in force, so they will not be affected. After all, 8.5 is lower than the 9 like Chinyara has already signed. So I agree with the amendment.
Thank you, honorable colleagues. In the public gallery this afternoon, we have a group of 29 sugarcane growers from Greater Mukono Sugarcane Outgrowers Cooperative Society. They are represented by members of parliament from Greater Mukono region. They've come to observe proceedings of this house. Please join me in welcoming them. And I can see in some of the faces that we had in the negotiations that took some. Yeah, thank you. Thank you. Honorable colleagues, in the public area this afternoon, we have a group of Scouts and Girl Guides leaders from the Uganda Scouts and Girl Guides Association who have been participating in a meeting with regards to the amendment of the Boy Scouts and Girl Guides Act. They are here to observe proceedings of the House on invitation of Honorable Sasaga Isaiah, Member of Parliament for Budadi East, who is also the Deputy Chairperson of the association. Please join me in welcoming them. Thank you. Honorable Batua.
Thank you, Honorable Chair. On the issue of rendement, I do not want to differ so much from what has been agreed. However, my contribution is that the 8.5% should actually be the minimum. My argument is that if we are to understand rendement as how sweet your sugarcane, you the farmer, how sweet your sugarcane is, and we who grow sugarcane, we know that when you leave it for long in the garden, it becomes sweeter. Therefore, rendement meaning that 100 tons of sugarcane, how many tons of sugar will it give? Here we are saying 8.5 tons of sugar. Minimum. We are saying the word negotiation should not arise, saying that those who negotiate for a higher rendement. Let there be a procedure in that those whose sugarcane has been tested and found to produce more than 8.5 at least get what they deserve. However, the minimum remains at 8.5.
Yeah, Honorable, those are issues which the council will handle
in their regulation.
Yeah,
the word negotiate, Honorable Minister, should not arise. We should be fair to a farmer who has fertilized and given long for the cane. Thank you very much, Honorable Chair.
Honorable Diomu, really, you want to comment on this? Honorable colleagues, I now put the question that Clause 13 be amended as proposed. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 13 as amended.
I put the question that Clause 13 as amended stands part of the bill. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 14.
I put the question that Clause 14 stands part of the bill. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 1.
I put the question. So, Honorable, these are clauses we stood over because we needed to first sort these issues. Honorable colleagues, now that we have sorted these other issues, I put the question that Clause 1 stands part of the bill. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 2.
Honorable colleagues, I put the question that Clause 2 stands part of the bill. Those in favor say aye, and to the contrary nay. The ayes have it.
Title.
Honorable colleagues, I put the question that the title stands part of the bill. Those in favor say aye, and to the contrary nay. The ayes have it.
Motion for the House to resume.
Honorable Minister.
Mr. Chairperson, I beg to move that the House do resume and the Committee of the whole House reports thereto.
Honorable colleagues, I put the question that the House do resume and the Committee of the whole House reports thereto. Those in favor say aye, and to the contrary nay. The ayes have it. Thank you.
Report from the Committee of the whole House.
Honorable Minister.
Mr. Speaker, I beg to report that the Committee of the whole House has considered the bill entitled the Sugar Amendment, Bill 2023, and passed it with amendments.
question that the Sugar Amendment Bill 2023 be read the third time and do pass. Those in favor say aye, and to the contrary nay. The ayes have it.
A bill for an act titled the Sugar Amendment Act 2025.
Thank you. Thank you, Honourable Minister. I want to congratulate you. I want to congratulate Chair. I want to congratulate members from the sugar growing areas and honourable colleagues for supporting them. You know, the members, and I want to really thank in a special way members who participated in the negotiations to listen to their farmers. These outgrowers here are very happy that at last, we have this resolved. Because then I will raise Honorable Kuzuru's issues later. Because every day we have been laying, these outgrowers have been suffering. Even when we've been putting government on task here to come and address issues of the sugar sector, our cane, we are getting a low price, there was no basis. The basis was clear in this, especially that formula. So, Honorable colleague, and thank you for fighting for your people and guiding us. They were hard, and there is no way presiding officer could proceed without first reconciling with the colleagues from the sugarcane growing areas. Now, for the and farmers, colleagues had a fear that there are people who didn't want this law to pass, and therefore will go and blame other colleagues. Whatever you didn't achieve, it's because your MPs went and passed the law. What we have passed here is what was negotiated between the mirrors and the outgrowers. The MPs came to support and to ensure that indeed you get a fair deal. So I don't want my MPs to be blackmailed or not supported. It might force some of us to come and explain to people who negotiated. So those who negotiated, please let us stand by that negotiation and explain to our people why it was very important to pass this important law. Honourable Minister.
Mr. Speaker, I want to thank you in particular for all the effort you have put in to make sure that these amendments are passed. You have chaired several meetings. We have negotiated, built consensus, and to this consensus that actually we have passed. I want to thank the members for supporting the amendment. We passed the law in 2020. It has been now coming to 5 years. I want to assure members that now we are going to work on the regulations. They might even come before the 4 months so that we implement the sugar bill and organize the industry. And I think, Mr. Speaker, could be an appropriate time that we check our sugar levels at this time. I thank you.
So, Chair, we made you suffer, inheriting, a bill in between, but you've done a fantastic job. We want to thank you. Please, if you have any comment you want to make as a committee chair, please.
Thank you so much, Mr. Speaker. Allow me to join the Honourable Minister to thank you for the tremendous job you have done. I would be very honest, first time I joined the meetings for the millers and the outgrowers, I thought it would not get an end to this, but I would like to thank the growers and the outmillers for finally having something on table, and definitely I'll thank the fellow honourable colleagues from the sugarcane growing districts and constituencies. They have joined you in this battle and it has been successful. Thank you so much.
Thank you, colleagues. House suspended for 30 minutes so that we can do lunch and be back here in 30 minutes. Thank you. Welcome back, colleagues. Let's resume. Next.
Item 3.2, Committee on Environment and Natural Resources.
Honorable Chair. Chair, our tradition has been we use 15 minutes so that because we read the report, then the whole report is captured on the Hansard so that we can save more time for members to debate.
Mr. Speaker, sir, honorable colleagues, I would like to thank you for this opportunity. Right Honorable Speaker, on behalf of the Committee on Environment and Natural Resources, I am pleased to present to you the report of the Committee on the Ministerial Policy Statements for 5 votes and 3 subventions. Mr. Speaker, we present a report on vote 017, Minister of Energy and Mineral Development, vote 139, Petroleum Authority of Uganda, vote 019, Minister of Water and Environment, vote 150, National Environment Management Authority, and vote 157, National Forestry Authority. Mr. Speaker, we have subventions which comprise National Water and Sewage Corporation, the Atomic Energy Council, and the Uganda Electricity Credit Capitalization Company. Mr. Speaker, before I go into the crux of the summary of our report, I would like to note here, Mr. Speaker, that a few colleagues here may be hearing that we return and talk about National Forestry Authority. Mr. Speaker, to this end, the bill rationalizing National Forestry Authority hasn't been assented to, and we believe that as a committee, we must be able to deal with our institution as long as it has not legally been rationalized yet. Mr. Speaker, I also want to note that even as we go into the report, that there has been severe underfunding of the Ministry of Water and Environment, where over the last financial year, they have experienced a cut of 54% on the budget that this House approved. Mr. Speaker, you will also note in our report that there is a very fundamental issue of poor funding for rural electrification as well as electricity scale-up projects, which are crucial projects for the transformation of this country. And Mr. Speaker, one of the final and key issues is the continued accumulation of unpaid water bills for National Water and Sewage Corporation to a tune of 107 billion, which is, to this end, threatening the healthy operation of the corporation. Mr. Speaker, therefore, I would like to say here that I will go straight. I beg to move to the committee observations and recommendations where I will delve into some of the issues I've highlighted. Ministry of Energy, the energy and mineral sector. In your report, honorable colleagues, it's on page 17. General observation. Right, Honorable Speaker, the committee noted that there was over-budgeting for the midstream petroleum infrastructure development project phase 2, which led to inflating of the ministry budget. Mr. Speaker, the budget for vote 017, Ministry of Energy and Mineral Development, for financial year 25-26 is projected to rise by 501.9 billion, and this will go to 1.714 billion from 1.212 trillion, 1.714 trillion from 1.212 trillion in financial year 24-25. This artificial increase is on account of the project called Mainstream Petroleum Infrastructure Project Phase 2, where the Ministry of Finance, Planning and Economic Development has lumped up a total of 653.4 billion as external financing without any detail of this project, not even its work plan. Mr. Speaker, the minister has also increased the government of Uganda funding for this particular project from 10.4 billion in the ministerial policy statement to 32.9 billion for this particular project. This artificial inflation or increase in the budget estimates is the one that has resulted into a rise in the ministry's budget. The committee recommends that the Ministry of Finance, Planning and Economic Development explains the basis for budgeting for 653.4 billion under midstream petroleum infrastructure development project phase 2 without any work plan against the multi-year project spending plan laid out in the House. Mr. Speaker, specific objectives. 1.
Chair, will you go into all that detail and manage?
Okay, Mr. Speaker, yes. May I talk about just the recommendation?
Recommendations.
Okay. Mr. Speaker, on the underfunding of the mineral sector, the committee notes that out of the planned 1.713 trillion, Mr. Speaker, these are units for debate in the House because there are 3 minutes and it's off. I beg that the floor may continue.
Please, IT do the needful.
Thank you, Mr. Speaker.
Allow Honorable Arko to show cause.
Yeah, Mr. Speaker, I thank you. Mr. Speaker, we will note that the petroleum sector is provided for with only 33.55 billion. And out of this, there is only 9 billion which is provided for development budget, which is representing only 1.9%. The committee therefore recommends that the government should provide adequate funding for various interventions under the mineral sector, such as exploration activities, quantification of mapped minerals, regularization of artisanal and small-scale mining. Mr. Speaker, on capitalization of the Uganda National Mining Company, the government has established a company, the National Mining Company, with a view of increasing beneficiation from the mineral sector. The committee noted that we need at least 4 billion shillings to be provided for the capitalization of this company. The committee therefore recommends that the government should provide 4 billion to the Uganda National Mining Company to take up its strategic mining operations in the country. Mr. Speaker, the establishing and gazetting of the artisanal mining zones and biometric registration of artisanal miners. Here, the committee recommends that the government provides additional funding of 2.9 billion for the regularization of artisanal mining and the gazetting of artisanal mining zones. Honorable colleagues, you will note that I am advised to concentrate on recommendations, whereas this particular sector would have required us to delve into the details of the committee findings. But because of challenges of time, I trust that you can follow the detail in the report itself. Colleagues, value addition. The committee recommends that the government provides additional funding of 10.5 billion for the construction and equipping of beneficiation centers. That is in terms of value addition in as far as minerals is concerned. The Building Substances Bill. Honorable colleagues, while processing the Minerals Bill 2022, the committee recommended that it was
Honorable, you started working here much earlier than me. Some of the people in IT, you're the one who recruited them, so I'm not to blame. He was our head of HR here in Parliament. So the people you recruited, if you had issues.
Right, Honorable Speaker, well noted and well agreed. I hope that I can return one day to do an evaluation of my recruitment processes. Mr. Speaker, I thank you. That the committee recommended that a specific building substances bill be introduced in the House. It was hoped that by April 2023, this bill should have been introduced. The committee therefore recommends that the building materials bill should be presented to Parliament by at least the end of the first quarter of the next financial year, as it has significant implications on the budget of the sector. Right Honorable Speaker, on the issue of staffing needs of the Directorate of Geological Surveys and Mines, the committee noted that it is important to strengthen the Directorate of Geological Surveys and Mines, because at the moment we only have 7 mine inspectors, 4 of them working in headquarters and only 3 in the field. We therefore recommend that 2.02 billion be allocated for the recruitment of key personnel in the Ministry of Energy and Mineral Development, with a recruitment that has been cleared by the Ministry of Public Service for financial year 25-26. And 2, that the recruited personnel should be facilitated with the tools, vehicles, and other essential equipment so as to ensure compliance monitoring. Construction of way bridges. Mr. Speaker, sir, the committee observed that despite securing parliamentary approval through the supplementary in financial 23-24 of UGX 10 billion to procure way bridges, the funds were never released. The committee therefore recommends that the ministry is provided with 4 billion in the financial year 25-26 for the mineral production monitoring system and the installation of way bridges at key mining sites so as to track the volumes of minerals extracted. Non-payment of royalties. Mr. Speaker, sir, the matter on royalties has been debated in this House severally. The committee therefore recommends that the royalties should be remitted Mr. Dungu and Tim, is that where it is operated from? Not here. Okay. Mr. Speaker, sir, because these are my staff, I am almost starting to address them directly. Mr. Speaker, that royalties should be remitted to local governments and other beneficiaries as per the Mining Act, Cap 159. 2, that the Ministry of Energy and Mineral Development should revoke licenses for exploration where the holders have been found to be carrying out mining as opposed to exploration. And indeed, exploration licenses must have a specific timeline to avoid people who do exploration while actually purport to do exploration while actually extracting minerals for commercial purposes. Energy and mineral development should strictly enforce all requirements for one to hold an exploration license and weed out the speculators. Operationalizing strategic mineral resources. Mr. Speaker, sir, the committee recommends that as part of the NDP4 and the tenfold growth strategy, government should prioritize reviving Katwe salt and Osukuru phosphate mines. It should also incentivize local iron ore processing so as to reduce imports, create jobs, and support industrialization. Mr. Speaker, under Sustainable Energy Development Program. Mr. Speaker, the energy program is where electricity issues are. One, contractor payment delays under the Rural Electrification Program. The committee noted that there is significant delay in government paying certificates of completed works. This, which has totaled to 75.622 billion as at June 2024. The non-payment of contractors has in turn resulted into the abandonment of sites in many parts of the country. Honorable colleagues, some of the erected poles are beginning to rot away. Some of the unenergized power lines have been vandalized by unscrupulous people. And indeed, this has resulted in failure of most of this project. The committee therefore recommends that UGX 75.622 billion be provided to the Ministry of Energy and Mineral Development for payment of contractors, consultants, and suppliers of materials to the various rural electrification projects. Strategy to complete contractor abandoned electrification projects. Mr. Speaker, sir, the committee recommends that government should provide the Ministry of Energy and Mineral Development with 20 billion shillings that it has requested for payment of new contracts who have been identified to undertake and complete abandoned project sites. Counterpart funds to unlock donor financing under the electricity scale-up project. Mr. Speaker, sir, up to a tune of 345.4 billion shillings in financial 25-26 is available from development. The ministry requires at least 21 billion shillings to unlock this funding as counterpart funds. Under the electricity scale-up project, it is hoped that up to 1,500 kilometers of network grid extension shall be completed, and another 300,000 last-mile connections could be done over the next financial years. Mr. Speaker, the committee therefore recommends that the government provides for counterpart funding for electricity scale-up project of 20 billion in the next financial year. The power tariff reduction and takeover of the distribution system by UEDCL. Mr. Speaker, the takeover of the electricity distribution system by UEDCL from Umeme Limited on April 1st, 2025 coincided with a 13.9 reduction in the weighted average end user tariff for the period April to June 2025. The exit of Umeme, which has hitherto been entitled to a net return on investment of 20%, made it possible for the regulator to provide UEDCL with $75 million of recoverable proceeds from the tariff for immediate investment into the network. The committee therefore recommends that UEDCL is provided with $75 million as money for capitalization of the company so as to enable it run the grid effectively. electricity demand growth, which is soon outstripping the available capacity. Honorable colleagues, the current installed capacity of electricity in the country is 2,051 megawatts. The actual available dependable capacity is approximately 1,372 megawatts. Honorable colleagues, it is expected that the annual demand of electricity is likely to rise by 10% from 7% over the next 5 years. This is going to be attributed to electricity scale-up project, the standard gauge railway, and the intensification of oil-related industry. This therefore means that this projected growth rate is anticipated to increase the demand of electricity to surpass the supply over the next 3 years. The committee noted that on average, it takes 5 to 9 years for one to design.
Procedure,
Right, Honorable. You've been giving 15 minutes to accomplish these reports by our committee chairpersons. And at this time, we are seeing that the committee chair is going into several details. We want it to be procedurally right. If upon every point, the committee chair, since already knows each matter, he first gives the observations in a small summary and later on explains to us the recommendation. We want it to be procedurally right.
Thank you. Now, honorable colleagues, I think there is a culture of us reading from here. Reading with the chair. What the chair says is what we know is in the report. But you're given these reports early, you have them on the iPad, so I need you to have time for debate. The more time a chair takes, the rest of the time you get for debate. Okay? So, but informed view, you've been with this report since last week. Okay? So chair, 5 minutes. Conclude. Because already the minutes are gone, and the whole report will be captured on the Hansard.
Mr. Speaker, sir.
Chair, please, your time is moving.
Mr. Speaker, sir. I want to get persuaded, Mr. Speaker, whereas dutifully and diligently following your guidance, I believe energy, minerals, water, environment form the core and the crux of the attainment of the NDP4 of this country. We only do not do our role as members of this House justice when we attempt not to want to listen to anything to do with the report. But as a committee, we are satisfied that we have scrutinized the MPS to its very detail, and we can defend the figures at Budget Committee. Therefore, honorable colleagues, I shall try to do as requested. The committee recommends. No,
but today, Honorable Ariko, you're not the Ariko, you know, because you usually concentrate. You are allowing forces from the sides, and you're very happy. You're very, very happy today. I don't know what.
Mr. Speaker, sir, the
Chair, I've added you 10 minutes.
Thank you, Mr.
Okay?
Speaker. Mr. Speaker,
let's count 10 minutes. Then, because like you've said, I want members from every sub-region of Uganda to submit on this.
Okay, Mr.
in
Speaker.
terms of a debate and feedback.
Mr. Speaker, I will definitely be done in the 10 minutes. In a move to enhance generation, honorable colleagues, government is exploring a possibility of undertaking an 8,400 nuclear power project in Buyende. Feasibility studies have started. The government also wishes to start a Center for Nuclear Science and Technology The purpose of this